Righty. Good afternoon, everyone, and welcome to another Insolvency Bites chats with me, Alice Rue from SMB Advisory, and the wonderful Stacy Miller of Cronin Litigation Lawyers. Hi, Stace.
Hi, Alice. Hey, everybody. Hope you've got some lunch ready to discuss an interesting case.
Absolutely. I'd like to begin today by acknowledging the traditional owners of the land upon which I live and work, the Yagara and Turrbal people, and pay my respects to elders past and present, and extend that to respect to all Aboriginal and Torres Strait Islander people on the call today. I would also just like to apologise in advance for my voice. I'm on Freedom Day. I've been in ISO with the dreaded COVID logie for the last, 7 days yesterday. So today I'm out. So bear with us, please. On that note, thank you everyone for joining us today in LinkedIn Live Land. We're also recording this. It will be available shortly after we finish recording on the Insolvency Bites YouTube channel. Today, we're talking about Intellicomms, Stacey. Intellicomms Pty Ltd in liquidation, and this is a case that takes a really good look at the issues surrounding director defeating dispositions. That's pursuant to Section 588 FDB of the Corporations Act, and it's the first of its kind to be decided. So, Stace, do you want to maybe give us some context by talking through those provisions and Phoenixes generally, just to kick us off?
Yeah, I think it would be a good idea to start there. As you've said, it's really is the first case that we've had a chance to look at this new provision in the Corporations Act. But let's just remind everybody about the existence of Part 5.7b of the Corporations Act, which provides somewhat of an arsenal of actions to a liquidator to recover property or money compensation to benefit creditors of a company once it goes into liquidation. So we're talking about your voidable transaction claims at Div 2 of that part. So it's your unfair preferences, your uncommercial transactions, unreasonable director-related transactions, and your insolvent transactions. Anyone who works in the insolvency space will be very well familiar with those voidable transaction claims. They often lead to or come about after investigations by a liquidator being conducted and a finding of some uncommercial element or maybe a non-arm's length transaction or some preferential treatment, which ultimately leads to an asset or a fund not being available to the general body of creditors. So they're being deprived of that asset. And the liquidator has this, as I said, arsenal of actions available to him or her to try and claw that back or to void that transaction and get some benefit back to the company. Mm-hmm. So this particular provision in this case, again, first time it's been applied by the courts. Good old Victoria beat everybody to it. Section 588 FDB, and it came about by virtue of the Treasury Laws Amendment, or I just call it Combating Illegal Phoenixing Act 2020.
It really says it all there, doesn't it?
Sorry?
Really says it all there.
Yes, combating illegal phenixing in the title of the legislation that came into effect in February 2020, just before COVID hit. Do you think, segue, do you think that maybe there was a bit of a delay with this case because of all the moratoriums in place and, a slowing down in the insolvency space, obviously, because of COVID?
Of course. Well, look, it very well could have been. The timing is absolutely sort of right for that assumption. I do think, though, that, to be honest, and we'll go into the facts in a moment, but the facts of this case are textbook. And,
absolutely.
Somebody who has, what they talk about, Phoenixes, it's sort of, what it is when you see it. It's quite hard to describe in certain aspects, but it's very hard as a liquidator, even with, the facts that we can get, to spell out a really strong case in terms of Phoenixing, just because there's so much circumstantial, assumptions and evidence and things put in that either the regulators or the courts can't really rely on, to go to the end. This, and again, we'll talk about in a moment, but, having full valuations over a set period of time really provides a really nice landscape that you can look and say, well, no, this is what happened. There's a runway there. So I think having the case was paramount. I don't know, and I'm not sure how recent again we'll see another one like it. I just think it was such a really nice little petri dish for us to look at.
I think there's lots sitting on lawyers' desks and liquidators' desks, but it's got to be worthwhile, obviously, taking it to court. But anyway, jumping ahead, obviously, good time to talk about phoenixing, because it's a term that we use to describe a liquidation of an insolvent company following transfer of assets to usually a related corporate entity, so that they can keep carrying on that business of that company that's about to go under without the burden of debts that company had incurred and carried with it. So, it's your Harry Potter phoenix rising from the ashes. But we do need to make a distinction between legal and illegal phoenixing. And there is a distinction. Phoenixing itself is not illegal, and that's why we say illegal phoenixing. And that's when there's a deliberate and systematic liquidation of a corporate entity, where there's that underlying and sometimes blatant, as we will see, fraudulent or illegal intent to avoid those liabilities, often tax. ATO is certainly probably the primary creditor that gets burned by illegal phoenixing. And then that intention to continue operating and taking profits from the business through another trading entity that no longer has those tax liabilities or employee entitlements or that unsecured creditor, because, left that to a liquidator to deal with. So it's interesting, when I was looking at this phoenixing, I was like, oh, what is a succinct way of explaining what illegal phoenixing is? But I came across this little explanation, and it was funny. I've copy-pasted this. It's key people required to set up a Phoenix company. And they list out, I can't even remember where I've pulled this from now. I think it was actually the ATO website. Pre-insolvency advisor. These are the key people required to set up an illegal Phoenix, I should say. A pre-insolvency advisor, a valuer, a liquidator, what we call a friendly liquidator. We could have a whole session about friendly liquidators one day, Alice. Can we put that on the list? Dummy directors and Phoenix operators. So I thought that was interesting that, you could list them out like that. But anyway, legal phoenixing, it can be done. You can actually rescue the business legally, but it covers situations where the previous owners or controllers of the company do in fact start another similar business using a new company after that earlier company fails, and they're trying to rescue the business, but they haven't along the way exploited the corporate form to the detriment of unsecured creditors. They've dealt with liabilities, or they haven't stripped assets at less than market value, or in a non-arm's length transaction. So you might have had a viable business that has been prematurely liquidated by an overly cautious director worried about insolvent trading. But the fundamental business is still sound, and there is the opportunity to trade under a different entity. Or there might be a business failure as a consequence, for example, of a pandemic, and forcing the company into liquidation. Doesn't mean that you have to scrap that business idea entirely. You can move forward in some circumstances. So there is that distinction to be made. So be mindful of your terminology sometimes when you're talking about this. And really, Section 588 FDB was introduced to target illegal phoenixing.
That's right.
So, as Alice has said, this case is the first of its kind to deal with Section 588 FDB. And I know the case talks about the section in specifics, Alice. But Alice is going to run us through the facts. So I'll hand it back over to you to do that, and we'll flesh out 588 FDB in the process.
Thanks, Stacey. And I will just and I'll probably cover off on this in a second as well, but there is an actual extract of the explanatory memorandum for the combating illegal phoenixing bill that is in the case, which I think is actually quite a nice, succinct way of dealing with it also. I'll also just mention at this juncture that we are happy to look at any questions that anyone might have if you want to pop them in the chat, and we'll try and deal with them as we see them. Otherwise, we can come back on advisement. But look, the case provides a really nice background, I must say, to this matter. And I'll just run that through now. But Stace, please feel free to jump in, because we'll talk about some of the specifics with that. So the first plaintiffs in the case were Glenn Franklin and Peter Vresky, who were the liquidators, and the second plaintiffs was Intellicomms Pty Ltd. So both of those parties made an application under Section 588FB as commercial transactions, 588FDA, unreasonable director-related transactions, 588FDB, creditor defeating dispositions, 588FE, voidable transactions, and 588FF of the Corporations Act for relief in relation to a sale agreement dated 8 September 2021 between Intellicomms and the defendant, Technology Fluenti, which is referred to throughout the case, and I'll do the same, as TF.
Yeah.
So the sale involved the sale of certain business assets, and that's really relevant as well. Certain business assets of Intellicomms to TF, and basically notes that until September 2021, Intellicomms operated a business providing translation services to commercial enterprises under the trading name EasySpeak in Australia, and also through a wholly owned subsidiary, Intellicomms New Zealand Limited, which operated, as you can imagine, in New Zealand. So then on the afternoon, so it all happened quite quickly, on the afternoon of the 8th of September 2021, so that's the same day as the sale, well, that is the sale, Intellicomms sold the assigned assets to TF under the sale agreement. And then a short time after that, on the same day, a meeting of Intellicomms was convened at short notice at the behest of its sole director, and Intellicomms was placed into creditors' voluntary liquidation. The liquidators were appointed, the liquidators in the winding up, at that time. So it's important then to look at TF. TF was incorporated on the 25th of August 2021. So that's, suspiciously close, isn't it? Less than a month before. We're talking about less than a couple of weeks, really.
Yeah.
2 weeks prior to the appointment of the liquidators. Now, the sole director of that company, of TF, is the sister of Ms. Haynes, who is the director of Intellicomms. Now, prior to the sale, Ms. Gigliotti, so that's the director of TF, was employed by Intellicomms as its financial and payroll administrator. What did you say, Stace? Who was your person, the dummy director or something?
A dummy director, yeah.
We could almost have done a diagram.
Yeah.
The essence of the relief that is sought by the plaintiffs is that the sale agreement be set aside by reason that it is a creditor defeating disposition within the meaning of 588 FDB of the Act, and avoidable transaction within the meaning of 588 FE 6B of the Act. Section 588 FDB was introduced to the Act by the Treasury Laws Amendment Combating Illegal Phoenixing, which we were discussing earlier. And this is the first time that the courts are dealing with the operation of this Act. Now, the explanatory memorandum, this is what I was sort of alluding to earlier, which introduced the relevant bill, observed in relation to Phoenix activity. And I do like this, this sort of statement. While the scale of illegal Phoenix activity ranges from the opportunistic to the systemic, a common characteristic is the stripping and transfer of assets from a company to another entity. Such transactions are carried out by a company's directors or other controlling minds with the intention of defeating the interests of the first company's creditors in that company's assets. Such transactions are also facilitated by others, including unscrupulous pre-insolvency advisors, accountants, lawyers, or other business advisors who advise on companies on how to engage in illegal Phoenix activities. The explanatory memorandum proceeded to observe that the legislation introduces new phoenixing offences to prohibit creditor defeating dispositions of company property penalise those who engage in or facilitate such dispositions, and allow liquidators and ASIC to recover such property. The explanatory memorandum went on to observe that in respect of Section 588 FDB, a creditor defeating disposition is a disposition of company property for less than its market value or the best price reasonably obtainable that has the effect of preventing, hindering, or significantly delaying the property becoming available to meet the demands. Meet the demands of the company's creditors in the winding up. So, Stace, do we want to talk about that quickly now in terms of that? There's 3 things I think we can pull out of that. So the creditor defeating disposition is a disposition of company property for less than market value or the best reasonably obtainable price. So they're obviously 2 different things. We've obviously got market value of the property or best reasonably obtainable price. And I think the case is quite clear in noting that there are situations where the market value may not always be obtainable in the interest of the company. So it may very well be that there is a lesser price that may be obtainable more quickly.
Yeah.
And I really think it doesn't sort of allude to it here, but I think that, bringing in that reasonable person stance really is relevant in this situation. If you're looking at whether or not there's a lesser price that is attainable, but it doesn't significantly hinder or delay the property becoming available to meet the demands of the company's creditors, then that's actually okay too.
Yeah, there's going to have to be, on a case-by-case basis, a real analysis of the context and the landscape in which this transaction takes place. So the Act, or the provision in the Act, provides for the lesser of the 2. If it's not market value, what is the best price reasonably obtainable, which might not be market value because of certain circumstances. Again, a pandemic, such a good example.
Yeah,
and we can finally use it after all these years without sounding silly.
No, and I think that's entirely appropriate. Absolutely. The decision goes on to that a particular asset.
Sorry.
You're right. I was going to say, a particular asset of the company not being available for division among creditors on winding up is not in and of itself a creditor defeating disposition. It's also necessary to establish that the company received consideration that was less than market value of the property disposed of and less than the best price reasonably obtainable for the disposition. So that test's applied at the time of the relevant agreement for the disposition of the property. If there's no agreement, then it happens at the time of the disposition. So in this context, market value means a price that would be paid in a hypothetical transaction between, and I always love these definitions, between a knowledgeable and willing but not anxious seller to a knowledgeable and willing but not anxious buyer who transact at arm's length. The ultimate test of best price reasonably obtainable recognises that there will be legitimate situations where a company may need to realise assets at less than market value. And that's what we were sort of talking about earlier. So moving on from that, we can sort of see here, there was a discussion in relation to voidable transactions, Stacey, but you covered off on that quite nicely earlier, and also I don't think it was pressed at the end of the day.
No, they didn't necessarily abandon the uncommercial transaction case or the unreasonable director-related transaction, but ultimately, spoiler alert, the finding that the transaction was void was enough, and they used this new 588 FDB instead. So it wasn't abandoned, but yes, not pressed.
So, as previously mentioned, the transaction, the subject of this proceeding, was entered into on the day that Intellicomms entered into creditors' voluntary liquidation. TF admitted that the sale agreement prevented the property from becoming available for the benefit of Intellicomms creditors in the winding up for the purposes of 588 FDB 1B, and that it was entered into when Intellicomms was insolvent for the purposes of Section 588 FE 6BB. So, Stacey, to me, it seems pretty textbook discussion about phoenixing generally. I'll note here, we've just had a comment, Carl Hagen's put one up about sort of talking about conveniently for the court and the liquidator, there were a number of decreasing valuations and evidence of suppression of the price. That is unusual. And that's, I totally agree. And I think that's what's made this matter quite convenient and easy for the court to decide in such a sort of black and white matter. As a result, the judgment did not provide guidance as to what constitutes undervalue. And I think that's right. But when we are looking, if we can look at the values for a moment and just, I guess, to sort of spell it out, I think there were 4 values, if I'm correct. There was one undertaken quite a bit earlier. I think it was February of that year. Now, that actually came in at something like 11 to 12 million.
It was 11.2 million 7 months prior to the sale transaction. So that valuation was the first of 4 and certainly the highest. So keep that figure in your mind, 11.2 million.
And then we've sort of come down, and I think this might be a convenient time to introduce QPC into our sort of our schedule of actors. And QPC was a shareholder. I think it owned almost 30% or around 30% of the shares of the company. I understand that QPC was a software provider or software developer that basically had the license for some of the software that was used by the company. So it was a supplier to the company as well. And my understanding reading the case was this initial valuation was actually entered into or procured for the purposes of increasing the shareholding of QPC and what that might look like from a financial point of view. So a very different purpose than trying to value the company for sale, 6-9 months later.
Yeah, I think from reading the case, and this is not an unusual set of circumstances either. You've got a minority shareholder who, and yes, QPC developed the platform and the software, and there's a really long relationship between QPC and Intellicomms, and this particular director of Intellicomms was a supplier. I can't recall from what I read whether or not the shares were acquired independently of that supplier, if there was some kind of contra arrangement early in the in the infancy of the company. But ultimately QPC was not just a supplier, it was an unpaid supplier and an unsecured creditor at the time of liquidation for something like $920,000. But there were negotiations going on between QPC and Intellicomms via the director for an increase in the shareholding of QPC, presumably in exchange for a reduction of the debt that was outstanding, and to improve the financial position of the company.
That's right. And I think not only an unpaid unsecured creditor, but an unpaid unsecured creditor that was had an expired or about to be expired stat demand that would lead to winding up application that was, I understand, due to be filed the 9th of September, the day after.
Yeah, so fast forward from these negotiations. So these started in around February, or were obviously existing in February when we got this $11.2 million valuation. Over the course of the next 6 odd months, that negotiation between QPC and Intellicomms really soured. I think the director became quite suspicious as to where QPC was angling itself. There's reference in the judgment to her evidence being that QPC was positioning itself for a hostile takeover, which really just, serves to highlight another one of her motivations in doing this. And the judge was quite critical of that. But that sort of explains, then the steps towards these other valuations, which took place over the course of the next few months. Well, I think there was a gap from February to July, and then there were 3 valuations in quick succession.
Correct. July, August, September. So just on that though, I guess just in terms of the mechanics of appointing liquidators in a creditor's voluntary liquidation, it's a liquidation that is basically done on the instigation of shareholders. So it's a different, a lot of voluntary administrations, creditors' voluntary liquidations, they have different ways of being appointed. of liquidators being appointed and the company actually going into liquidation. And it's important, I think, in this instance to note that QPC was a shareholder, which meant that it needed to not only basically vote on to pass a resolution that the company go into liquidation and the liquidators be appointed, but also consent to short notice. So there is this sort of process that goes by where the directors say, we think the company needs to be wound up, and they put a resolution to the shareholders, but there needs to call a shareholders meeting. And a lot of times, the Constitution will note that that's a 21-day sort of process or thereabouts. But there's a mechanism where with 95%, I think it is, of the shareholding agreeing, you can have short notice and basically call that second meeting straight away. Now, what's evident here is QPC, who were about to wind up the company as an unsecured creditor in any event, were approached by the director of Intellicomms and saying, okay, well, I'll appoint a liquidator, or we'll appoint a liquidator now. We're insolvent, that's what we'll do. QPC agreed to the short notice and obviously agreed to a liquidator being appointed. However, at no point in time during that process were they enlivened to the fact that the business had actually been sold, which is a material issue, obviously, and one that is very relevant, you would think, to QPC, who are looking to buy.
And from QPC's perspective, sitting there as a creditor and a shareholder, attends this meeting, agrees to short notice, obviously has its own concerns about solvency, as why else would you issue a stat demand, informed by the director, and QPC's director gave evidence about this, and it wasn't refuted by the director of Intellicomms, so it was evidence that was not contested, gave evidence that the Intellicomms director said, okay, have called this meeting on advice, Q entry of the pre-insolvency advisors, dare I say. And she also informed the meeting that no assets of Intellicom had been sold other than office equipment. That was the evidence of the QPC director. Now, bear in mind that the assets of this type of company, and it's detailed in the judgment, are significant. You're not just talking about some office equipment. You're talking about goodwill, software, trademarks, website contracts. The revenue for the company was generated from some fairly large key customer contracts, the likes of Optus, Bupa, the New Zealand government, and Origin Energy. So, some big contracts. Yeah. And Intellicomms in turn then had contracted about 700 subcontractors to perform the translation services. So it's a big business, but that type of business is really heavily dependent on its software. So bear in mind, QPC obviously has a lot of direct knowledge about the value of that software and that platform because it developed it. So QPC sitting there voting in favour of a liquidator being appointed, had in fact started that process itself, has not been told that the assets of the business has all been sold, and is likely sitting there thinking, okay, there is going to be scope for us to buy the business off the liquidator, which is exactly what should have occurred.
And similarly, I think, and again, it goes back to that whole reasonableness situation and looking at this by virtue, like as a case study, but this is also a really prime situation for a voluntary administration. So to actually come in and have the business continue to trade and to be sold as a going concern, for that sale process to be driven through the administration process with the administrator sort of overseeing that, either coming out as a deed of company arrangement in that same vehicle or, having the business sold off as a going concern. And I think the court mentions quite a few times that there was every opportunity, and it was only her. So she's the only director. She could have. We talk about the shareholders putting in a company into liquidation as a creditor's voluntary liquidation. The directors put the company in to an administration. So she didn't have to go through anybody else. So it's the fact that she didn't do that really drove, didn't it, to her state of mind and her intent of keeping this business away from the creditors or from QPC probably in the main, which again sort of led it to be quite a good sort of textbook case to look at.
Yeah, and bear in mind when that, and the judge is quite critical of that as well, not taking advantage of your voluntary administration process. But we keep coming back to this being textbook case. When you think about the director, the employees of Intellicom, which included 4 of her relatives, so I think 2 siblings and their partners, so some in-laws. And this new company incorporated 2 weeks earlier, where her sister goes in as the director, has all the knowledge after being the financial and payroll administrator for Intellicomms while she worked there. She really is transferring it over to a new entity that she's going to, perhaps not be the director of from immediately, but she's got a dummy director sitting in there waiting for her. Later found that the employees of technology, or TF, were also relatives of Rebecca. So, they haven't even been very clever, very smart.
And the other part of that is just to come in and, it's great, this matter, because there's so much to tease out of it. But just on that, so if there had been, a liquidation or a voluntary administration, it has to be a liquidation for FEG to come into play. But if that was an issue, and we had a company sitting there and those employees remained in that company and there was amounts, that might have been sought from FEG, or even through the sort of, the dividend waterfall, there are specific sections and there's specific carve-outs for employees that are relatives of the director.
Yeah.
And so again, it's one of those things that just doesn't sit right, does it? Because it's like, well, if you've done it, and I use the word properly loosely, but if you've done it properly in a number of ways, you could have done it properly a number of ways. I don't think there's one set way, but if you've done it properly, there are a number of people that probably would have, potentially should have, missed out than the way that you are doing it to look after yourself and your nearest.
Yeah.
And
well,
I think
it's right. They did. There were liabilities transferred over in this sale, and that was the employee liabilities. So she has looked after her relatives. Yeah. So the business and the assets were sold. No liabilities carried over, but for those employee liabilities attached to the transferring employees, which were probably, I think there were 11 employees of Intellicomms, and there might have been 3 or 4 that were relatives. I don't know whether only 3 or 4 transferred over, but that would be another very telling sign.
No, I think I actually think 10 of the 11 transferred, but one of the other issues that we've got here is there's this contra against. So maybe this is a time to go back to the valuations. Now, so we were looking at the amount 11 million. So 11.
Yeah, we started 11 in February.
Yeah, 277,346. And whilst that was a February val, it was done basically to reflect the value as at 30 June 2020. So I think that's relevant as well. So then you're right, as things start getting a little bit hairier, and the 26th of July, there's a valuation undertaken. And that basically gives a valuation between 117,456 and 683,559. Now, that's a huge range, but I think it's a convenient time to sort of point out that valuing businesses, it's not a science, and it's something that people do take, or business valuers take have a lot of faith of the information that they're given. So it's interesting having a liquidator hat and a business valuer hat on, because as a liquidator, I'm like, well, where did that number come from? Where did that number come from? Why is that the number? Whereas as a valuer, you actually say, and there's a lot of carve-outs, I've been given this information. This information, I have not audited it. I've been given it. It's come, and you carve out. It's come from here. It's come from here. It's come from here. These are the assumptions that I've made. These are the multiples that I'm using. These are the discount, multiples that I'm putting in place. And you flow that through, right? And that's really interesting, because as a liquidator, that I find it incredibly difficult to have one hat on and then one hat off, because that inquisitorial fact doesn't reign.
You can't turn that off.
No, it's very difficult. But that's why you can have this huge range. And obviously, when FTI went in to do this market value, they've said, well, we've been given this information, and because of all of the information we've got, it could be anything from 117,456 to 683,559.
Yeah.
So we then go on to August, and we have another valuer again that comes in, and at this time is only valuing the goodwill. And I think this is interesting too, because we're valuing different things as we go along. So, the 11 million is valuing the business as a going concern for a share sale type arrangement. When we're looking at valuing everything, I think the fair value market of the equity in the company is what the FTI valuation was for. Then we go on to the August valuation, and it is a valuation of the goodwill of the business. So that's not bringing in anything of what you're talking about before, the website, the equipment, it's the goodwill, and that's 101,000. And that same value, I understand, goes back in September on some adjusted information and brings the value down to $57,000. So we're down at 57,000. Now, the amount that was ultimately paid was that 57,000, as I understand it, less the assumed liabilities.
Yeah.
So we assumed these liabilities, which I think were around 27 odd thousand, which brought about a $20,000 physical payment that needed to be made. Now, that assumption of liability, that was the employee liabilities, as you spelled out, that actually included one of the liabilities that didn't get transferred, one of the employees that didn't get transferred, but they didn't adjust the liability amount, which again, sort of understandably, it was rushed through. But there are these very notable inconsistencies to the actual value.
Yeah.
Attributed to the company.
It's a good time to point out that of this, I think it's like 65-page judgment, a good 50 of those pages talks about the valuation. So it's quite detailed. Dare I say those are the bits that I really skimmed. But look, I mean, when you look at the Feb val down to July, that's an $11 million difference. So it's really quite significant. But even that July FTI consulting valuation, the director's evidence was not prepared to accept it. That was the extent of her evidence, just wasn't prepared to accept it. And then, as you've pointed out, when we get to August and September, the business is not being valued. That is not, I can't see how they can say that's a valuation of the business. And the judgment refers to, and I've just been looking at it while you've been speaking, Alice, to the evidence of one of the lawyers for the liquidator, who just sort of goes through and deposes to some of the things that obviously the other side were put on notice of. But the August valuation, which valued it at 101,000, and the September valuation, that valuation was premised on a couple of things. One, assuming major contracts were lost, but it also expressly stated that they did not take into account value of the shares in Intellicomms NZ, which, we sort of haven't gone through the structure of the company much, but that held value in that related entity, nor the value of any overseas contracts of Intellicomms, which included the New Zealand contracts. And there was a contract with the New Zealand government. I don't know how much that contract was worth. But when you start, oh yes, I do. It says that in the next paragraph. New Zealand contracts alone are worth 2.47 million per annum. So when you start getting really creative with your valuations in the way that dear Ms. Rebecca Haynes has gotten creative, you really can't be surprised when the judge, when he starts going through final reasonings, starts really ripping her one, about how she's orchestrated these valuations, and says that she's done all this so that she could arrive at a valuation to minimize the consideration payable. And this is where he says that her motive for doing so was to prevent QPC, the shareholder and largest creditor, from having the opportunity to purchase what assets Intellicom had, either from a liquidator or an administrator. It is just so blatant. And that word is also used together with one of my favourites, audacious, which I do not get to use often enough. But these valuations, you know, I'm surprised there's almost 50 pages dealing with them, but because they're just a joke.
I really thought it was interesting. There was a reference to a New South Wales Court of Appeal Court decision in Crawley and Short, which also noted that where a specific purchaser is known to be interested in a property and has made an offer to buy it, evidence is receivable of such an offer and indeed may set the floor when determining market value. And that's really relevant here because we do know that QPC were interested, you know, and we're looking at what potential they could offer to buy the company. And so even though you've got this, you know, vast array of valuations on the other side on whatever different bases were available, and it may very well have been the fact that Ms. Haynes didn't provide the valuers with any information around QPC wanting to purchase the company or the business, that's a really material fact that really, and we say this all the time, you know, that's why we put a lot of our properties up for auction, for example, or we, you know, we have a marketing process that we go through because the market sets the market value. You can say that something's market value, but if you don't have that hypothetical and knowledgeable but less than anxious purchaser who's there to actually make the offer, then it's not worth it. And we see that every day at the moment in terms of, and we know we're not talking about property here, but when you actually look at property at the moment, you can say it's worth whatever you want it to say it's worth, but it's the market's going to pay for it, which is actually value. So when you have somebody or a party who is prepared to pay for it, that's got to at least set the floor, one would think, in terms of the value of that. The other thing I wanted to raise, which it's alluded to here, not much is made of it, but you talk about the New Zealand company that also sort of basically Ms. Haynes was a director of that, and it wasn't the subject to liquidation. And it can be quite difficult to have your appointment as a liquidator noted in terms of wholly owned subsidiaries and shareholdings and that sort of thing. So understandably, in New Zealand, she was still able to transact on that account, notwithstanding that the liquidators, as I understand it, had written to the Bank of New Zealand and said, please, no. But they said, well, give us a court order because as far as we can see, you're not appointed over our company. So we understand that. But very soon before the liquidation, which happened on the same day as the sale agreement, there was an amount of $30,000 that was paid from Intellicomms New Zealand to TF. Now, that could very well have been the same $30,000 that then was used to buy the assets of Intellicom, which in itself has a lot of issues. And that's, as I said, it's not delved into at any great depth here, but it's used as an example of how TF is using the assets of Intellicom still when it should really have not had the ability to do that. But things like that in itself, you can't have a company provide the money to purchase its own assets.
Yeah, exactly.
It doesn't really make a lot of sense to me. But being mindful of the time, should we go through what actually was decided at the end?
Yes, we can do that. One of the things I was actually just going to point out in that vein. So due to the timing of the appointment, so you've got she enters the sale agreement on the 8th and they appoint on the 8th. So the sale agreement's only been entered into, not completed. And that's an important point. And the liquidators declined to proceed with the sale agreement on basis of a very quick view formed about the agreement. It wasn't arm's length, it was uncommercial, likely an insolvent transaction. But they also declined to sign a license agreement between Intellicomms and TF, which TF was trying to get them to agree to, and which was supposed to enable the TF to operate. But obviously they were doing things anyway. And one of the other issues which comes up in the judgment is that this sharing of bank accounts, or TF had debtors of Intellicomms Pay to a new bank account or a shared bank account, and I think that was about $129,000 as well. Alice. So I just want to point out that there are a couple other little issues as well along the way, which are the sorts of issues that you do see in these types of textbook cases as well. Just the intermingling of funds and not being particularly tidy about separation of these two related entities and how they doing all the mechanics of this. It's they're supposed to be highly sophisticated illegal phoenixing activity, but I just don't feel like anything was highly sophisticated about this one, which makes it another good example. The other thing
I think that's a really important point, and I'll take your note from earlier that we probably need to have a discussion on untrustworthy advisors. I know AFS has put out some material recently that's been very helpful as well in that area. But you talk about these sophisticated, and they're not. And this is the thing that gets me every time. You have a lot of business people, and debtors who pay a lot of money, thinking, I think a lot of people think they're doing the right thing. They're going to an advisor, they're getting, told how to do a specific thing. But I've seen a number of things in terms of unsigned sale agreements. Well, too bad, so sad. The company's not, the business isn't sold. It's back in the liquidation. And you find out later that there's upwards of $40,000 or $50,000 that's been paid in relation to that transaction that just merely doesn't. It's not that it's a phoenix. It would be if they signed the agreement. You'd have something to, you'd be looking at the non-compliant activity there. But it's not even. That's not even done. I mean, I've had a matter before where we've walked up and asked for the books and records of the company, and the director said to me, "Do you want the ones that I do or the ones that the advisors told me?" So again, not very sophisticated.
No.
And I think that's a really a misnomer that we have, that there's all these, criminal masterminds in the background, and I'm just not sure that that's the case.
Yeah. And I know we've talked about untrustworthy advisors before, and we will again, and it's a bit of a watch this space. And actually we'll come back to that, because let's talk about ultimately what the relief was that was sought and then what the relief was that was provided. And then there's a couple of other sections of the Act that were introduced by that legislation in 2020 that I think it's worthwhile us touching on. But the relief that the liquidators were seeking, and the plaintiff, included the company, was that the sale agreement be set aside on the basis that it was a creditor defeating transaction in accordance with 588 FDB. And then they also sought a transfer back of the assigned assets. And you'll see in the decision, there's arguments against that by the defendants, that it shouldn't be transferred back, and that's an unusual or a rarity, that would actually happen, and too much time has passed and all that kind of thing. But ultimately, the transaction was voided. And one of the things that the QPC or the plaintiffs gave evidence about, which I think supported their transfer back order that they were seeking, was that the QPC gave an indicative purchase price in discussions with the liquidator that it was looking at for the business. And presumably this is at that time of liquidation and not back in February, of 500 to $1 million. So, there was some, and that really is indicative of the best possible realizable price, if not market value.
Absolutely.
So I mean, it'd be interesting to know what happened since the case. So was this June? No, how long ago was this now? May,
wasn't it?
Yeah. So I haven't seen final orders because, as often happens, the judge sends them away to come back with a final form of order that potentially they agree to. But presumably, that, just that the transaction was voided. What flows from there is that the assets remain with the company. And therefore with the liquidators to deal with and to enter into sale negotiations with the likes of people like QPC.
Yeah, I think another interesting point to that is, now whilst TF are saying, well, we've added value, we can't just give it back to you because, there's been, different transactions that have happened and investments that have been made into the company, that means that it's not, into the business, that means that it's not the same business that we basically received in September 2021. one has to think about the destruction that has occurred to the value of the company as well by virtue of that transaction. And I'm not meaning, obviously Intellicomms has been adversely affected because the business is transferred, but the business, if you just look at it, in its own little bubble, there's got to have been, disadvantages to that, to have gone through all of these issues. I mean, things like, supplier agreements and employee relationships, and you're dealing with the contractors. And we are assuming that I think they've actually said they've transferred their software platform now. Do we know? We don't know if that's better or worse or just the same, or, you've got to pay to think about that as well, that you might get the business back, but it may not be what it looked like in a worse way than it was when it actually was transferred.
Well, that's right. And the defendants therefore argue against that, and they say the more appropriate order or relief would be to pay the difference between the value that was paid and the value that the court then provides. But of course, on their arguments, that amount is about $2,000.
Yes, that's right, exactly.
But just to highlight then those the submissions that they make about that, they say the character of the assigned assets will have changed since the period since the transfer under the sale agreement. Secondly, complete restoration of the business is not likely to be possible. Thirdly, the property transferred under the sale agreement may not be able to be completely reassigned to the plaintiffs, but they just transferred the goodwill. That was just what was valued.
I mean, that's true. That's what was valued. Exactly.
Yeah. And further steps will be required in order to realise a return on the assigned assets, which will require incurring of costs by liquidators and contribute to uncertainty as to the ultimate outcome of the liquidation for creditors. Look, these are not necessarily inappropriate submissions or submissions that are without foundation, but what renders them unplausible or just not able to be maintained is that we're talking about the difference between what they say should be $2,000 odd worth of relief in the context of an indicative offer from QPC of $500,000 to $1 million. So there's just no merit to some argument that the liquidator couldn't be able to restore the company to a position that was going to be of benefit to the creditors. And the judge just really saw through it. I mean, I said earlier that he uses the word audacious and blatant, and, he talks about how the director embarked on a plan to frustrate the legitimate motives of QPC in retrieving its commercial position. Like, there's gems all the way through. Like, this type of decision is, a lawyer's dream. It's to be, I know that case. I'm gonna pluck that precise wording out and put it in into that letter. Where this one, I love this. Such transactions are also facilitated by others, including unscrupulous pre-insolvency advisors.
There's a lot of descriptors. That's for sure. I think I'd like to go on to those other sections, Stacey, we're talking about. Can I just raise one more thing that I think, again, talking to the value, and I must admit, I did read the other 50-odd pages of the valuation.
Yeah, because you've got that background. Where am I?
Well, I didn't realise I was that interested. Like, I've done the odd business valuation here and there. But one thing I thought was really, really interesting is that counsel for TF actually contended that in order for the sale agreement to be a creditor-defeating disposition, the liquidators needed to establish sufficient evidence upon which the court could determine the actual monetary value as to the market value of the assets and the best price reasonably obtainable for the assets, and that in each case, those actual values must be higher than the consideration paid by Intellicomms, or payable to Intellicomms, by TF. Now, the judge actually said he doesn't agree with that submission at all, and noted, and I just think this is really relevant, that the liquidators are required to establish that on the balance of probabilities, the consideration payable under the sale agreement was less than both limbs contained in 588 FTB. And I think that that's just really sensible.
I think it's a key one for everyone to note. So that's a paragraph 235 of the judgment. again, this is the first time we've seen this new provision applied. So, perhaps someone will come back and it might not even be a higher authority, but might take a different view on that. But this is what we have to go by at the moment. So this is good authority, certainly for now. And look, I think I agree. I mean, to have to actually prove the actual monetary value, is that going above and beyond what the court needs to establish to otherwise satisfy those limbs of 588 FTB? I don't think so.
It's hard. And I liked in this case where the liquidators said, we don't have to do that, but we can, and here is why. And I actually found that really quite nuanced. And I think that's right, because as Carl said earlier in his comment, this is so convenient that we have the levels of valuations that, this analysis can be undertaken, but it's very rarely the case.
Yeah. All right, so let's jump really quickly. So that Combating Illegal Financing Act that we talked about before in 2020, it introduced a few other provisions that are supplement or complementary. So look specifically to Section 588, capital G, A, B, which is in a similar vein to your director's duty to prevent insolvent trading. It's the director's duty to prevent creditor defeating transactions. Let me just pull it here so I don't tell you the wrong thing, but it's definitely 588 GAB. I thought I had tabbed. Yeah, officer's duty to prevent creditor defeating disposition. And the other one, which I think is going to be really, really interesting when we see it applied, could have been applied here, but there wasn't too much focus on the role of the pre-insolvency advisor on this one. But check out Section 588, capital GAC. So a person must not procure creditor defeating dispositions. So we're talking about not just the directors and officers, but advisors of corporations, including your lawyers and your accountants, who I'm sure are not doing anything unscrupulous, but they need to be conscious of their involvement in these potentially creditor defeating dispositions. Preparing transaction documents, giving advice about setting up bank accounts and all that kind of thing. Look at the context of in which you're giving that advice, because you may fall foul of that Section 588, capital GAC, and may be construed as an aiding, abetting, counsel or procuring a contravention under Section 79 of the Corporations Act. How exciting. I can't wait for the first decision dealing with that.
I think it's really relevant to note as well, Stacey, though, that ASIC has been looking at these aiding and abetting laws for quite some time, and they have had, I think, some successful prosecutions in that regard. But it is doing things. I mean, we all talk about, regulators and what can be done to actually, discourage the involvement of some of these unregulated and unscrupulous advisors. And I do accept that can be difficult in these situations. But things that I understand ASIC have been doing over some time is, in terms of that aiding and abetting, as a liquidator, we sort of obviously, by virtue of our Section 533 reports, investigations and reports to ASIC, we are encouraged to note where certain advisors continue to pop up or where we're seeing, advice being given that, isn't necessarily in line with the spirit of the Corporations Act. We also know that now that we have to file as liquidators our DIRIs, our declarations of relevant relationships and indemnities on appointment, with ASIC, and that is data mined. So ASIC are looking at, and you were referring to friendly liquidators earlier, they're looking at where liquidators get their appointments from, and they are actually sort of asking questions. And I think that's a great thing. And because, the liquidators are the regulated population. We are the ones that should be held up, to a standard that we are trusted and how we can sort of administer our obligations and what we need to do under the Corporations Act. That I think it is, it's important that we are held to a standard and questions are asked as to how people are dealing with certain appointments or certain relationships. And I do understand that is being done by ASIC in the background.
Excellent.
All right. Is that us? I think we're almost out of time.
That's us. I just had my clock going.
I
Just time
enjoyed that
flies
chat
when you're
today.
having fun, talking about
It does.
exciting
We're
cases.
talking about stuff. Thanks everybody for joining us. As I said, we'll have this up on our YouTube channel after we finish up here. As always, let us know if there's anything in particular you'd like us to have a chat about. Stace and I, we obviously will go through the facts of the case, but we like to look at these things from the actual practical perspectives of a legal practitioner and an insolvency practitioner who works in this sort of world every day. So if there's anything that you'd like us to go through, please let us know. Also, keep an eye out for, whilst we know you love seeing our amazing faces once a month on these in this format, we are looking at actually having a separate podcast come into being in the near future where we'll look at relevant insolvency topics and probably more from a, I'd say from a legislation point of view, Stace, as opposed to, specific cases. So keep an eye out for that. But other than that, thanks very much for spending your lunchtime with us today. We hope you got something out of it and we look forward to seeing you next time. Thank you.
Thanks, everyone.